Hi all, this might be a good time to say welcome to the meeting, and we're going to take a minute just to allow the rest of the folk to join us. But if somebody would like to say hello back, then I will know we've got good communication. Is there anybody there?
The mics and cameras will be off,
I
but
thought they were
we'll
on.
use Q&A, yeah.
Fiona Newman, thank you for your message. I imagine everyone's had a full day. It's great that you could join us this evening, but hopefully the traffic has diminished in noise a little bit. It's a bit noisy here in Christchurch, which is where I'm based. My name's Caroline, by the way. If you haven't met, I'll do proper introductions shortly. We'll give folks a couple more minutes. Okay, folks, I think probably we ought to kick off and people will join us as they're able to. But very warm welcome to you all. We're delighted that there was such a high response to the offer, and I'd really like to say thank you very much for making the time to participate in the webinar. Now, it might just be something you're happy to just absorb it all, go away, think about, and come back to us with questions later. But if I could begin just with a few introductions. I'm Caroline Johnson. I am a New Zealand Red Cross philanthropy advisor. I'm joined by my colleague Rob High, and I'm based in the South Island and Rob in the North. So Rob will be able to assist with some of the Q&As that arise later. Thank you to Public Trust for hosting the webinar. We'll be joined shortly, and I look forward to introducing you to Carissa and to Kim. Both are in the trustee area, so they are experts in their field and can help answer questions. I'd like to suggest that the aim of the session is to introduce you to the tools and the information that can make all aspects of will writing and understanding the free online will easy. If you have any questions, please refer to the Q&A tab at the top, just as you would in a normal chat, or if you prefer, save them up till the end when there'll be a chunk of Q&As happening. So the kind of things that we anticipated already might be at the back of people's mind. Questions like, what happens if I don't have a will? What if I have no next of kin? Can I use the offer if some of my assets are overseas? And who should witness my will? And where will it be stored when I've completed it? These are the kind of generic questions which a lot of people have. And by asking a question today, you'll be helping others on the call too. The call is being recorded, and for that reason, you can be reassured that if you miss anything this time around, we'll be sending that recording to you a few days after the event. So there are links to further information in your email invitation, but I encourage you to ask questions today. The session won't offer financial advice, but can answer most general questions about will writing and the online tool. So I'm going to click to the next screen to show you just an image of what our My Life and Legacy record looks like. The My Life and Legacy booklet was created by Red Cross about 16 months ago, and it's been designed as a record that will help you prepare your will. It is not the actual will document itself, which is a legal document. But it was designed by the philanthropy team so that you could have a one-stop shop for your executor and for your family to know where to find your important documents. So, for example, an EPA, an enduring power of attorney, is often completed at the same time as a will, and that too is a legal document. But in this booklet, you would simply record that you've got one. So from the top, you'll use it to prepare instructions for your executor. You'll use it to record where to find your important documents or passwords. to record important milestones in your life as a record for family, or for your wishes for your funeral service or your life celebration. And in this document, you'll also find that it provides the correct legal wording for a solicitor to understand your wish to leave a gift in your will to New Zealand Red Cross. I think the value of this document is not only that you get your thoughts together before you start entering the main document, but it does describe your wishes with less legalese, so it can provide a little bit more context about why certain choices were made. And sometimes, you know, the issue of fairness is something that worries people, so it's good to be able to explain yourself in a bit more detail. There's also a section for medical history. There's information about the funeral, I mentioned that. But as I've said, a number of things that are not legal records, but are frankly very helpful for the person who has the difficult task of writing your life celebration eulogy. They would, for example, you know, they would remember that Mum was a keen gardener, but they may not perhaps mention that she was also a 30-year member of Red Cross. And that's something which, for those members of the branch sitting in the congregation at the time of their celebration, they would love to have that mentioned. So it gives you a bit of control and a bit of influence. And as I said, things like our charities commission number, information that helps to identify a charity, all ensures that the gift is directed to the right cause and purpose, and that information is also in the booklet. So if you have decided to use this booklet to prepare for your legal will writing document, congratulations on deciding to be prepared, because you are actually saving your family additional distress in a difficult time. Now, the next slide that we'll flick to now, really, I would like to stress that this will writing offer has no strings attached. It is a benefit to our staff and our volunteers and members. So all gifts to New Zealand Red Cross are appreciated, but not expected. Of course, we'd love you to consider leaving a gift and hope that if you do, you will tell us so, because we'd like to thank you. So humanitarian legacy is, of course, the purpose of such a gift, and your support can make an immense difference, reaching thousands of vulnerable people through our humanitarian work, responding to disasters and emergencies, helping in humanitarian crises, perhaps delivering Meals on Wheels for somebody who needs a connection in their day as much as a meal, and supporting former refugees. So in all these ways, once you've taken care of family and friends, a gift to a cause that's been important to you throughout your lifetime is often one that can make a world of difference. But of course, they come in all sizes and all are appreciated. One of the most popular types of gift, because people do ask that quite often, is a residual gift, because that is designed to enable you to leave all your gifts to family and friends first, and only after that the residue may simply be left to the charity of your choosing. And gifts and wills help us plan, so that's why a deferred gift, which is what a gift and a will is, it's just a gift that happens later when, for example, it might be more affordable. This is a way of contributing that has a lasting and positive impact. So without further ado, I think we'll get into the main information. I'd like to pass over to Carissa, a trustee at the Public Trust, who can tell you a little bit more about the online tool and about the way that your will can help to protect your wishes.
Thank you so much for that, and thank you everyone for joining us today. As said, I'm Carissa, I'm the Kapiti Public Trustee, and with me today we've actually got Litsa from our Hawke's Bay team, and I believe Felix and Aima are going to help out on the chat function too, so you've got a bit of a combo happening there. We've got quite a bit to cover off today, so let's just start off with a question to reflect on. How would you feel if your partner passed away and you were told that you had to pay out your partner's children to remain in the home you shared? Now, that may be one scenario you or a loved one is facing if there isn't a current will in place. I'll talk a little bit more about that later, but first let me share that approximately 50% of New Zealanders do not have an up-to-date will. Without a will, you can leave your loved ones facing legal and financial difficulties. So today I'm going to give you a very brief overview of public trust. We'll talk about leaving a legacy for those that are as important to you. And then we'll just cover off through a few slides that things that we find that are commonly asked: how to look after your loved ones in your will, the role of an executor and trustee, what happens if you don't have a will, and how to get started in updating your will. Litsa will close off by covering off what happens for decision making, not just on your passing, but also during your lifetime, which is equally as important. All going well with our time frame, we'll be having some time to answer questions in the chat, so do pop those questions in there. There will be some that are answered as we go along. By the end of today, you'll have some information to move forward in protecting what matters for the people or the organisations that matter most to you. If you have any questions, as I said, please put them in the chat function. Bear in mind that today's time frame is limited, so if your question is one that requires more personalised details answer, we may refer you to our local public trust for one-on-one assistance, so that today we can do our best to cover off as much as possible. Right at the top of the chat, there's a link to Public Trust website for a very common answer. A question is, what are our fees and charges? And I've also included a link to the great booklet that Caroline was just talking about. I think it's a wonderful resource that was really, really helpful on somebody's passing. So we've got the link there. It's really accessible. Take the time to have a look at it when you have some time. So just very briefly about Public Trust, we recently celebrated 150 years of being in existence. We're a Crown-owned entity. We were established to provide professional and impartial trustee services. Each year we write about 7,600 wills, and we manage the legacies of about 1,400 of our customers through administering their estate upon their death. As I mentioned, Litsa will cover off enduring powers of attorney. We also do things like trusts. They can be family trusts, prepaid funeral trusts, or even charitable trusts. We can either act in estate administration, either being the executor and trustee, or we can help those that are appointed through our Executor Assist service, where we take the technical work, such as the probate applications, tax returns, financial records, and things like that, and leave them off that side of things while they still remain in control of the decision making. And perhaps a bit less well known, we also have a private manager service. One of the things we do is that we are the auditor for the financial records where somebody doesn't have an enduring power of attorney and an individual is appointed as their property manager. So that's just quickly about us. Let's talk about what happens when you die. What will your legacy be? There's a variety of priorities for individuals, and these can be summarised by some people, if you wanted to categorise them, as emotional legacies, social legacies, or spiritual legacies. And without getting too in depth in that side of things, emotional legacies are what we may want our loved ones to be left with a sense of security and stability. A social legacy means we want our loved ones to have learnt the fine art of relating to people so that that helps them cope well in life. And then obviously a spiritual legacy is important for those that want to leave a legacy of attitudes and belief about spiritual matters. For Public Trust, when we recently completed research, 85% of people wanted to prioritise leaving an emotional legacy. That's leaving our loved ones with a sense of an enduring sense of security and stability. Yet, as I said at the beginning, 50% of New Zealanders still do not have an up-to-date will. And as someone that's been with Public Trust for 28 years, I find it really interesting that the research that was done in my early years still says it's around about 50%. So we've got a long way to go in people changing their sense of need to keep this information up to date, and Public Trust is reaching out to people through organisations such as Red Cross to provide some information about how to preserve your legacy. So what do you need to consider when ensuring that your legacy plan is current? A will is a legal document that is uniquely yours. It sets out your wishes, it names who is responsible for carrying out those wishes, and gives specific directions on the things that we've got listed on the screen there. For assets, anything that you own over the value of $15,000 requires a thing called probate, formal estate administration. Now, interestingly, in February 2023, 3.5 million people were recorded as having a KiwiSaver. You can't jointly own a KiwiSaver, so over time it's most likely that most people will have accumulated at least 15,000 in their KiwiSaver alone. But there's things like life insurances and however you may own properties and things like that, bank accounts and investments. Friends and family, obviously, who is it that you're wanting to provide for? But it may even include things such as your pets. Mementos, what is precious to you that you want to ensure goes to the right person or is retained? Bequests, any charities that you want to provide for, such as the Red Cross that we're talking through today. The funeral, what are your wishes in this regard? As Caroline covered off a little bit of that today as well. And then finally, a statement of wishes. This can be a really important thing because it covers off any other special instructions you may have or background information that you want to have known or be your voice upon your passing. So take a moment to reflect on that and think about your own situation. Some people ask me, what is it that you think, how do we know when to change our will? So the top 5 reasons for having or changing your will is any of these particular 5 circumstances. Have they occurred since you last wrote your will, or do you have a will? So one of them is relationship changes, beginning, ending, changing. Another one is children. They may be born, sadly pass away. Relationships may break down or relationships may have been mended. Grandchildren, the same situation applies. Significant asset purchases such as your house, KiwiSaver, life insurance, or changing financial circumstances, inheritances, relationships starting or ending that change your financial circumstances, mortgages repaid and that you're now developing savings. If any of that applies to you, or there may be some sort of flicker of, oh, I must check about that, why don't you pull out your will and have a look if it's still current? We've got a great offer going through the Red Cross, so it's a really good opportunity to take that time to have a look. What is an executor? It's a great word, but what does it actually mean? It seems a lot in my observations that quite often people say a name, but what does that mean for that person that they've appointed? They're going to carry out your instructions within your will. There's 3 core opportunities or options really that you can appoint. You can appoint a professional such as a solicitor or a trustee firm such as Public Trust. You can appoint an individual person or persons such as a family member or friend. You can appoint an individual who then engages the services such as Public Trust through our Executor Assist, where they will maintain the control of things, but they'll get the additional support for the legal, accountancy or financial records, that side of things. An executor role in itself holds a lot of responsibilities and time commitments, and even financial liability pertaining to the actions that they take. An executor can also end up being involved in legal proceedings should the will be challenged. Some of the issues that we've seen over the years that they may be faced with, one of is the obvious. If you've appointed an individual person that they've known you personally, they too will be going through grief and having to deal with that with the immediate responsibility of legal and financial matters. Conflict. There may be blended or strained relationships to deal with. Time. My observations of recent times, I think there's a minimum of at least 20 hours work when there's not even a house involved. A house, I think there's at least 35 hours worth of work, if not more. Houses these days are more and more having a little bit, the market's changed, what may or may not can be done and what will occur. Legal interpretation. Was it a poorly written will? Was it an old will? Was there interpretation of clauses that is really causing concern? Overseas assets or family or beneficiaries. This is becoming more and more a common challenge to navigate as New Zealanders evolve in various different areas of the world. Legal obligations and liabilities, as we mentioned, how they manage the funds, what and how much they sell assets such as houses for, who they distribute to. Paperwork and lots of paperwork. Probate applications, tax return, financial statements, communication, lots of communications. These days with emails, people are firing off questions, which is wonderful, but it takes time to reply to those. Transparency is such an important thing with an executorship role. Who has the full transparency to make the decisions, timely lists of the actions and the costs incurred? Just as a matter of interest for public trust, when we're an executor or trustee, our transparency goes quite far through both our ministerial obligations right through to we have an independent service that will audit us should the beneficiaries request at no charge to them, where at any point in time there has any concerns. For an executor and trustee, they have what I refer to as many hats or responsibilities to wear. They may be a beneficiary of the estate or have a close relationship with somebody, but they must remain neutral. The court has endorsed this and held them to account in that regard, and they may be held liable if they've not only taken their responsibility to ensure that the beneficiary's wishes are considered, but if someone makes a claim, they have an obligation to consider that as well. So in choosing your executor and trustee is a vitally important part of your will. What happens if you don't have a will? Now, this is what I started off my conversation about. A lot of people do not realise that if you have assets at the value of $15,000 in your name, then a will is required, the legal process called probate. Now, it might be upon your immediate death, or it might be that your spouse has passed away and now everything is in your sole name. If you don't have a will, if there is a spouse or partner, but no parents, children, or other descendants, it's relatively straightforward, but still a lot of paperwork. The spouse or partner receives the whole estate. But if there's a spouse or partner and children or other descendants, then it gets a little bit more complicated as to the assets in the deceased name. The spouse will get the chattels plus $155,000 and only 1/3 of anything left. The children will receive the remaining 2/3. And then unusually, that many people aren't aware of, that if a spouse and partner and parents survive, but there are no children or descendants, then the spouse or partner will receive the chattels plus the $155,000 and 2/3 of the remaining estate of the deceased, and the parents will receive 1/3. The application process has to go through the court, and it takes time and money to do. So this is just a really quick reference for you about through Public Trust, we've got a couple of options of how you can get started. Hopefully just from a quick fire of what I've done for you there, you've got a sense of the importance of having a will and having the right people involved in it. We offer two options through Public Trust. We've got a fantastic online service. This option is really great because you can do it within the comfort of your home. You can do it over a period of time. You can come back and forth. You can have a chat to your loved ones if that's what's important to you. Seek advice if you need to do so. Equally, you can have face-to-face appointments. And again, you may want time to have an exploratory conversation. Go away and consider that and come back. So there's some great options available to you. So have a think about that. If you enjoy technology, you can go on, there's a little prompter function on our system to work out what option is best for you, or alternatively, you can just give us a call and we can work through the options for you. And then obviously booking an appointment or printing and signing, making sure everything is current is really important. Just flicking over to the screen there, sorry, bumping that away. What I'm going to do is hand over to Litsa now to talk about making the decisions while you're alive.
Okay, thank you. Now, an enduring power of attorney is a legal document that enables you to choose a family member, a friend, or an organisation like Public Trust, and they act as an attorney to make decisions on your behalf when you cannot make decisions. Now, there's one for your property power of attorney, which includes your financial assets, which includes bank accounts, shares, your property. So whatever other financial transactions you may have. And there's one for the personal care and welfare. The personal care and welfare deals with your personal decisions, whether the person talks to the doctors, whether you need an urgent operation, who is going to sign for you, or if you just need someone to talk to on your behalf. When you appoint someone as a enduring power of attorney, they're actually stepping in your shoes. So whatever you do now, whoever you appoint can do the same thing. Now, there's the power of attorney for property can come into effect whether you've got capacity or no capacity. You have a choice of when you want this person to act or an organisation. The personal care and welfare power of attorney only comes into effect if you lose capacity. And the only way they can use that is getting a medical certificate from the doctors to say whether you've got capacity or not. You can easily do these online, or you can come into the office and prepare the powers of attorney. It's a simple process. If you don't have any of these powers of attorney in place, a court order would have to be done, and you're looking in the vicinity of about $8,000 to $10,000 to do a court order to have someone be appointed property manager. And then again, if you go through the courts, then they have to reapply every 3 years to get the order extended. So it's quite important to have the powers of attorney, because they take care of you when you pass, when you are alive, and the world takes care of you when you depart this world.
Thanks, Litsa. So this is hopefully all going well with my technical skills. What we'll do now is I'll just give you a little bit of a very brief introduction on the online function that we have available for you.
Sorry, the sound's not working this time.
Oops, sorry.
I think you might need to reshare. Sound's not displaying this time.
Sorry, is that technically not working and my screen's gone a bit funny?
Yeah, just
There we go.
stop sharing for a second and reshare
Yep.
with that audio slider.
Oh, here we go. My apologies. It was going well up until now. Just bear with me. How's that? Hopefully that's showed through for you there. One of the things I just wanted to highlight for you, that as a valued supporter of Red Cross, we wanted to highlight how easy it is to leave the options of gifting in your will. So once you go on and register for the online service, which is just as simple as signing up there is an option when you get to fill out the various information that's referred to as specific gifts, and it's really quite simple. The wording will be generated for you so that it's correctly done, which is really important when you do something like that. So you select the option of yes for that you do wish to provide for a gift. You specify what gift, because it could be of any sorts, whether it's for an individual person or a charity, so all sorts of things there. But using the example of a charitable gift here, you can select the sum of a cash sum type option, put the amount that you want to provide for there, and then the quick, easy access that we have got there is you can nominate a person or a charity. You can go a variety of charities, but just for your ease of reference, we've popped the Red Cross in there. So it's as simple as clicking on that, and it will bring up all of the correct legal wording that's required for this particular charity. So to close off, thank you so much for the opportunity to speak to you. Please feel free to contact us. We are going to have a look into the chat line now and see if there is any questions there. We're more than happy to help you, and we're located throughout New Zealand. As I said, there's the information through our website. It's relatively a quick, easy follow through there, but please don't hesitate to call on the 0800 number if you prefer. I did want to also just do another reiteration of the fabulous Red Cross resource, My Life and Legacy. I think it's a wonderful way to capture all those important aspects of leaving a legacy. I know for my own self, when I had a loved one passed away through an accident, for me, I was really tired, really exhausted, and the brain just could not function. So that ability to just pick up that information and pass it over to an executor and trustee to say, here, this is what everything that you need. I think that's a wonderful resource. So really encourage you guys to utilise that. And that's available in the link as well. So Caroline and Litsa or Felix, do we want to just have a look and see if there's any questions in the chat?
Hey, Carissa, I know it hasn't been asked, but one question that does come up a lot is having overseas assets, and how does that get handled with your will, and leaving gifts? And the second question is, can you leave someone out of a will? Yeah,
that's really, really common questions. So overseas assets is a couple of things that we would reference in that. It depends on the country. They can have such variable processes. One of the things that we would encourage that is you want to have a look that if you've got a significant asset such as a property, it is well worth investigating and having a will in that country, because they'll have their own legal process by which that asset can be realised, uplifted, sold, transferred. So that's an option that you can do. And then within your will here, you can say that this will covers everything but that country, or that it includes all countries anywhere. Yes, we most certainly can deal with it. We can engage services over there. It's just sometimes it's worth having a chat with us about that, because there may be options that we could do that maybe present a more cost-effective option for you, or a little bit more of a smoother process for your family to deal with. A lot of countries can be really variable as to their responses to estates. The other option that you said to me was about, can I leave someone out in your will? One of the things I've heard things like, I think the one I heard the other day was, if you leave someone 50 cents in your will, that they can't contest your will. That's not true. Another one I heard was, if you leave them, I guess it's probably conceptually the same thing. If you leave them a specific gift, then they can't contest your will. No, that's not true. There's mainly 3 to 4 main acts. There's the Family Protection Act. It doesn't say actually who you should provide how much for. It just simply says there's a moral obligation to provide for certain people. And so those people may determine that there is, you've breached their moral obligation. You haven't adequately provided for them. So that there is only certain family members. It's not everybody. It's spouse, children, grandchildren, in some cases, stepchildren, if you have a parental relationship, and even in some cases parents, where you might be, it's like a role reversal situation where they're dependent on you. There's a thing called the Testamentary Promises Act that says that if you promise something to somebody when you die, it's not, hey, you can have this when I die. It's, if you do this for me, I will give you this when I die. If you mow my lawns 10 times a year, I'll give you my lawnmower when I die. Probably that's a little bit of a literal example, but a more common one that we see is, hey, I don't want to go into rest home care, so if you come and live with me so that I don't need to do that, I'll make sure you're looked after in my will. Maybe the person came and looked after you for, say, 10 years and you left them $500 in your will. They may think that that is not a reasonable return of the promise alluded to. There's also a thing called the Property Relationship Act. So if you're in a relationship with somebody, whether marital or not, they also have a right to be provided. It's an extremely broad act. There's about 8 different ways that you can be deemed as being in a relationship. It can be that you're deemed in public together as a couple. It might be shared expenses, things like that. There is a thing called mirror wills, a little bit more common, whereby if you've done mutual intention, you might have said you've got a husband and wife situation, and you've both mutually agreed, look, I'll look after you, you look after me, but when we both die, we agree that my kids will get 50% and your kids will get 50%. And then when the second person passes away and they've received everything, they cut out the other person's children or leave it all to the SPCA or something like that, then there may be some claims under mirror will side of things there. There's lots of different little cases about that. One I think I found quite interesting too is that it may be that, for example, even if you died without a will, then there may even be claims pertaining to that. So one of the ones that we're aware of a case that went through, and it's a public record information, whereby a person passed away without a will, and the neighbour actually made a claim on behalf of their children, saying that over the long period of time that they'd lived together, they actually developed a family relationship, and they successfully had their children awarded provisions under the person's will. So that's a very quick way of saying that there is a wide variety of ways by which somebody may express an interest or an intention to claim under your will. And that with that comes a lot of responsibilities for the executor and trustee.
Would you agree, Carissa, Caroline speaking, would you agree that it's often a very good idea when you've gone through your planning process to just share some information with your family or your executor?
That's a really interesting question. Over the years, I must admit, I've probably preferred to emphasize the importance of having a robust conversation with a professional when you do your will. I think the importance is making sure you've had that conversation with your executor and trustee about what they are willing and able to do. The concern I have of if you discuss to what degree you discuss with other people that may be in the will is that, what if you change your mind? Are you then feeling like obliged that you've got to discuss that? Well, then does it give you a degree of independence, impartiality? Some of it might depend on your relationships and the dynamics there, but it is important. I guess the emphasis I would more place on is making sure that if you've got dynamics that you want to discuss, I think having somebody in the first instance that's independent and impartial to talk that through is really important, and then determining from there who you would like to involve in any pre-discussions. And again, I just emphasize having all of that information available, such as in the resource book that you have. And then the other thing that I mentioned, which is on our list of things, is the statement of wishes. So if you are thinking that there's the potential that somebody may raise question or concern over your will, we can work with you to draft what's called a statement of wishes. So we can extract from you the various information that is really important to convey your voice, so that if in the event that sadly someone objected to your will and it went through a court proceeding and the judge sort of said, well, why? Then that's your point of view conveyed. So I a little bit err on the importance of getting independent, impartial advice first, and then determining from there what's the appropriate conversations to have with your loved ones.
Thanks for that, Carissa. It makes perfect sense, and I do think people sometimes think it doesn't apply to them, but for anybody who's got stuff, you need to make some decisions about what happens to it. Usually a good policy is to put things in writing, so the opportunity to use the booklet to do that and then speak to a professional is a very good one. And I would also add that it's really good for us if you do that. If you've chosen to leave a gift in your will to Red Cross or a charity, it's simple that we would prefer family not to be unhappy with the decision. But ultimately, it is your decision what you do. But it just it's kind of nice if people are prepared, and then there's no surprises within the family unit.
One thing I was just going to jump in there, Caroline, and mention, if I may, is that there's also an option which a lot of people maybe aren't aware of, is that when you're leaving a legacy or an amount in your will or things like that, you can have the option of doing a specific amount or a percentage. Now, the thing to remember with wills is if you do specific gifts, whether it's the house, it's in a cash amount, under the terms of the will, they always go first, and then the residue is what left is divided up amongst whomever you've named. So some people prefer the option of leaving a percentage. So say, for example, I'm only just purely picking a number out of the hat. They might say, I'm going to leave 5% to these two charities and 95% divided equally amongst my children. What that means is that if your asset value goes up, then it's still proportionately the same, but possibly a little bit more importantly, if your asset value goes down. Say, for example, you entered into rest home care and you're having to pay for your care, your assets significantly change in that time. Proportionately, it will still stay the same. Whatever that percentage of that 5% is 5% of the estate at that point in time. So that's just an option that some people may want to discuss. That was good English. And to consider whether that's a worthwhile option to provide.
Thank you. Nobody's raised the question, but I do know somebody commented to me that they were interested to know what was the requirement to witness and the obligation around storage of the will once it was written online. And I know that Public Trust have an excellent website with very well worded links to specific information. But would you be able to just touch on that, please, Carissa?
Yes, it's really important with your will. There is a legal requirement by which the will is what's called executed, completed. There's a couple of important things there. When you do your online will signing, if you choose to do it within the comfort of your home, we will give you a guideline to how to cover that, or alternatively, you can come and see us and have it carried out here. But in short, it's really important that you have two witnesses, and the witnesses should not be beneficiaries of their will, or unfortunately they will, exclude themselves by that way. So it's really important that they're independent witnesses. They must be present at the same time. It can't be you sign it in presence of one and then another person goes, oh, yep, that's you, 2 days later and signs. It must be signed in the presence. They are witnessing that they have witnessed you reading over and that they feel comfortable that you have read and understood and not entering into it of any duress. You must have it dated correctly. And so, yeah, there's components that make up a will. I reflect back on before joining Public Trust when I thought I was a good old Kiwi and DIY willed it through a Whitcoulls in that time. Now I sort of roll my eyes in horror as to what that would have been. So it's really important to use a good a portal that you can use, such as an online facility or professional organisation, to make sure what you have got is something that can be legally binding and not raise question over the legality of it or how it should be executed.
Thank you. I know a couple of more practical questions again, one of which is, in terms of storing that will, some people will be familiar with popping into an office and completing a will. It may be the first time they've completed a will online. So am I correct in thinking that having entered the template and followed your very easy to follow bouncing ball through each decision-making part of the process, in conclusion, you can then say that you've completed the activity? As mentioned earlier in the chat, there is an opportunity, typically up to 30 days, people are going in and out because they've thought of something else and they wanted just to tweak slightly. And of course, there's always an opportunity to update later, although a small charge may become applicable, and the link to information about that is now on the chat. But is it the case that information is stored confidentially, so effectively you can print and have a copy of what you have created, but you can also ask Public Trust to keep a copy of that for you, or even, if you prefer, go into an office to have that conversation?
Yes, you can. So Public Trust, particularly where we are the executor and trustee of a will, we store wills free of charge. Our online portal has the option of you uploading your will to the system. If you have any problems with that, please feel free to come into your local branch and we can assist you with that. I think that's moving with technology, a really good option. I also see the value of making sure it's stored in a common place. Again, just relating back to my own experience of the the exhaustion that I felt at the time, and for the life of me, I couldn't think of get the brain to function, particularly in the initial few weeks. And just knowing that it's there, and going back to your question about telling somebody, you know, talking to someone about your will, I think it's really good to let people know, hey, if something happened to me, all my paperwork is held here with, you know, with Public Trust, just get in contact with them, that type of thing, or with my solicitor. That's a really good option. So you don't need to tell them the content of it if you don't want to, but where to get started, particularly for your executor and trustee, is really important. So important to make sure it's stored safely. The probate process is very particular. If it's seen that there's a staple or a rip or a tear or a smudge or a coffee mark on it, then there's extra paperwork that has to be done to tell the court that no, it hasn't been doctored or edited or anything like that. So keeping it in a safe place. You know, we've experienced some recent tragedies over the years, such as earthquakes and things like that. So again, hopefully having it in a secure, robust place is a really important thing to do. I will also mention just very quickly there, when you appoint an enduring power of attorney, if you're doing an enduring power of attorney for property and it has immediate effect, do be aware that they would be entitled to see a copy of their will should they ask for it, if the document has immediate effect and is pertaining to anything of your legal and financial affairs. So they may at some point access that. And then there is also questions, excuse me, under the enduring power of attorney about whether they have the ability to change it.
Thank you, Carissa. That's really good advice. I'm not seeing too many questions coming through now. I'm sure people will have other questions. They'll think of them after we've concluded the webinar. So my advice at this point would be really good information in the links in the invitation you received to answer questions through the Public Trust website. They're the legal will writing experts. If the information is more concerning, perhaps a gift you'd like to make to Red Cross, then do contact a philanthropy advisor. As I mentioned, Rob High in the North Island, myself in the South. But if you just go to the bequests we'll pop a slide up now for you, which has just got some key points of contact, but effectively an email to requests@redcross.org.nz. If there's a question that you weren't able to find an answer to when you looked at the website, don't hesitate to call on us to help you. We'll try to assist. And in addition to that, it's an opportunity now for me to say thank you to everybody who's participated. Don't be put off thinking this is a big deal if you haven't done it before. The rewards are so great for those people that do choose to put their wishes in writing and to make sure that it can be found. It saves your family quite a lot of unhappiness. And Chris, I've had the same experience when I haven't had that benefit, and it is a really difficult position to be in. So do try to be really positive about the fact that you're doing a good thing here, that it's an opportunity to influence how things should turn out rather than leave it to chance. So I hope you'll feel encouraged to make a start. Don't forget, this is there is access to help. So there is the online chat, which you can put a question in at any time. And you will be answered not by a robot, but by one of these lovely people at Public Trust who'll be able to explain clearly what the answer is to your question. So please do that if it helps you. And finally, I'd just like to say, if you do choose to leave a gift for Red Cross, please do let us know. We really do care and wish to thank you. And we're happy to provide further information if you need it. So without further ado, I'd like to close the meeting by saying thank you, team, for presenting the information today, and thank every one of you for making this important decision to try to leave your gift in a will and your wishes known through the My Life and Legacy booklet, which can be either obtained hard copy or downloaded and even emailed to other members of your family if you'd like that little preparation booklet to be shared further afield. So thank you again, and do keep in touch. Bye-bye.
Thanks very much. Bye.
Bye.
Thanks.